C and Article 27, subsection 4, and Article 73, subsection 1A and 2 of the Constitution, as read together with Article 131, subsection 2C and D of the Constitution. The Honourable Member for Kibwezi has listed charge number 2 as gross violation of Articles 147, subsection 1, 152, subsection 1 of the Constitution, where he claims the Deputy President has been undermining the President and the Cabinet and the effective discharge of the national government, which is the executive mandate. Gross violation of the Constitution on grounds number 160, subsection 1 of the Constitution, on matters institutional and decisional independence of judges is yet another charge. This is charge number 4 in regards to this special motion. Charge number 5 pertains the gross violation of Articles 3, subsection 1, and Articles 148, subsection 5A of the Constitution on the fidelity of the oath of office. In the motion, the Honourable Member says that the Deputy President breached his oath of office and allegiance on account of utterances and actions attributed to his office, that is the office of the Deputy President, under grounds number 1, 2, and 3. Grounds number 1, 2, and 3 are gross violation of articles of the Constitution. And charge number 3 is in regards to the gross violation of Articles 6, subsection 2, where the member says that under the 4th schedule of the Constitution, the Deputy President has been undermining devolution. Apart from the 11 charges stated in the special motion this morning, the Honourable Members of Parliament who signed for the impeachment motion in their numbers, that is 291, have been listed in today's order paper this morning, technically indicating that the business of the consideration of this special motion, which will stand as a substantive motion this morning by Honourable Member for Kibwezi West, Honourable Mwengi Mutuse, will be ready for debate and voting today. Well, and to just take you through more in regards to this special motion that members of the National Assembly will be debating and voting on this morning, is that the standing orders of the National Assembly, according to the newly amended standing orders of the 13th Parliament, standing orders number 64, subsection 2 of the National Assembly, accords the House a number of 7 days to dispose of a motion after the notice has been given. We had the member for Kibwezi West giving a notice of motion in regards to the impeachment of the Deputy President, which was given on the 1st of October. The House has until today, which is the 8th of October, to debate as well as vote on the motion. According to the rulings by the Speaker of the National Assembly, the House requires 233 members for the charges to be upheld. So what we expect this morning is that we'll be expecting the tabling of the report of Matters Public Participation Exercise that was conducted on the 2nd and the 5th of October. Remember, after the House gazetted the 2nd of October as the day for public participation, we had an extension of 1 day, and we will be expecting that report that was presided over by clerks of the National Assembly across the 47 counties to be tabled this morning. Thereafter, the tabling of that report that will hugely inform the debate as well as probably guide members in regards to the manner in which the House will be voting for the motion today on a sitting that is set to take place from 9 a.m. up to midnight, which is has been listed as upon conclusion of this business. The mover of the motion will be called upon to move his motion. Honourable Mwengi Mutuse has been allocated an hour to move the motion and, so to speak, convince members in regards to the grounds that he has listed in the motion. Members of Parliament will equally this afternoon, as well as for the better part of this morning, be debating this motion. It has been allocated about 7 hours for debate by members. We'll also be expecting the Deputy President, Honorable Rigathi Gachagua, to appear before the National Assembly plenary this morning as well as afternoon at a time appointed by the Speaker in his defense in regards to the 11 charges leveled against him by the member for Kibwezi West, Honorable Mwengi Mutuse. By the end of business today or before midnight, the House will have decided on the fate of this motion. We require about 233 members to vote to uphold the charges for the impeachment, and under Articles 145 and 150 of the Constitution, if the motion is supported by 233 members of the National Assembly, the Speaker of the National Assembly, Honorable Moses Wetangula, will then communicate in regards to the upholding of the impeachment of the Deputy President to the Speaker of the Senate within 2 days. And in the event that the motion does not meet the required threshold, that is 233 members of the National Assembly, then the motion stands defeated and the Deputy President of the Republic of Kenya continues to hold office. We are awaiting for the business of the National Assembly to commence any moment from now to consider the impeachment motion against the Deputy President of the Republic of Kenya. And in the event that this motion is upheld today, that is before midnight, and the Speaker of the National Assembly communicates to the Senate Speaker, Honorable Amason Kingi, in regards to the decision by the House to impeach the Deputy President, the Speaker of the Senate, in regards to the Constitution and the standing orders of the Senate, is expected and must convene a sitting of the Senate within 7 days of receiving the resolution of the National Assembly. And after convening a sitting of the Senate, the House must decide either to establish an 11-member committee or to investigate the charges facing the Deputy President under plenary, where all the 67 senators will be hearing the matter in plenary before voting. Similarly, as in the National Assembly, where the Deputy President, Honorable Rigathi Gachagua, will today be expected to appear in his defense and convince the members of the National Assembly as to why the grounds listed in the special motion do not hold any water. In the event the House upholds his impeachment or votes to impeach him, the Deputy President will equally be expected to appear yet again at the Senate to convince senators as to why the House should not uphold his impeachment by the National Assembly. In regards to the Constitution of Kenya and the House standing orders, the Senate must conclude the investigation, hearing and voting on matters impeachment yet again within 10 days after it is convened and has received a resolution from the National Assembly. At the Senate, we will be needing at least 45 senators to vote in favor of the impeachment motion for any of the charges to be upheld, for the Deputy President to cease from holding office. But that will be a matter of wait and see to see if indeed this motion that has 11 grounds listed as the grounds for impeachment will be making its way to the Senate after the House votes to impeach the Honorable Deputy President Rigathi Gachagua, or if indeed the matter will be resting today if the House fails to attain the required number of 233 members. Dear viewers, remember, an impeachment by the National Assembly has to be vetoed by the Senate of Kenya, and in the moment and in the event the House votes to impeach the Deputy President, that matter must be heard and decided yet again at the Senate, where the House will be investigating whether the National Assembly indeed had substantiated the 11 grounds for the removal from office of the Deputy President. Now it is upon the Honorable Member for Kibwezi West, Honorable Mwengi Mutuse, as well as his witnesses, to convince the House that his 11 grounds really do hold water and the Deputy President really has committed an offense or offenses that, so to speak, warrant an impeachment. And to just take you through the grounds for the impeachment this morning, among them is a gross misconduct by persistently bullying state and public officers. This is charge number 11. Charge number 10, Honorable Mwengi Mutuse has accused the Deputy President of gross misconduct by openly or publicly insubordinating the President, who is the head of state and government. That the Deputy President has shown gross misconduct that is incapable with the high calling and dignified state of the office of the President, and equally having served as a member of the Cabinet and a member of the National Security Council. According to the move of the motion, the Deputy President, Honorable Rigathi Gachagua, has publicly attacked and undermined the work of the National Intelligence Service and its offices and officers. The further grounds listed in the motion by the mover is that, according to the mover of this motion, there are serious reasons to believe that the Deputy President has committed gross economic crimes under Article 45, subsection 1, Article 46 and 47, subsection A and 3 of the Constitution in regards to the Proceeds of Anti-Corruption and Economic Crimes Act. This is in regards to the Proceeds of Crime and Anti-Money Laundering Act. Dear viewers, if you're just joining us, the business of the National Assembly is just about to commence. The Speaker's procession, closely followed by the Speaker of the National Assembly, has made its way into the chamber this morning, signaling that the business of the National Assembly is just about to commence any moment now. Allow me to hand over for this live broadcast brought to you by the Kenya Broadcasting Corporation in partnership with the Parliamentary Broadcasting Unit. My name is Gladys Mungai. Have yourself a great morning.
Waheshimiwa, tuombe. Ewe Mwenyezi Mungu, ambaye kwa hekima na wema wako umetoa nyadhifa za viongozi na mabunge kwa ustawi wa jamii na utawala wa haki wa wanadamu. Tukusihi utazame kwa neema nyingi sisi watumishi wako ambao wameridhika kutuita ili tutekeleze shughuli muhimu za jamhuri yetu. Tunakuomba uteremshie baraka zako sisi tuliokutanika hapa, na utujalie tuyatende na kufikiria mambo yote yatakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili utukufu na sifa zako siendelezwe, na ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen. Honorable members, we have quorum to transact business. Clerk.
Order number 1, administration of oath. Order number 2, communication from the chair.
Take your seats. Member for Trans Nzoia, take the nearest seat. Honorable members, I have a short communication in relation to the motion for the removal from office by impeachment of His Excellency Gachagua, EGH, as the Deputy President of the Republic of Kenya. Honorable members, as you will recall, on Tuesday, 1st October 2024, the member for Kibwezi West, the Honorable Ekomas Mwengi Mutuse MP, gave notice of a special motion seeking a resolution of the House for the removal from office by impeachment of His Excellency Gachagua, EGH, as the Deputy President of the Republic of Kenya. Thereafter, upon consideration of the notice, the House Business Committee, at its sitting of the same day, resolved inter alia that the sitting of Thursday, 3rd October 2024 be suspended, which it was, that in the intervening period, the Clerk of the National Assembly collects and collates public views on the proposed impeachment on Friday, 4th October 2024. Members at the bar, take the nearest seats. Take the nearest seat. Okay. That a procedural motion be moved to provide for the speaking time during the debate on the special motion, and that consideration of the special motion be undertaken today, Tuesday, 8th October 2024. Honorable members, as you are aware, public participation sessions were held on 4th and 5th October 2024 in all constituencies. I also note that the public participation exercise, which commenced on 2nd October 2024 with the invite to members of the public to submit views, included the collection of physical and electronic views, some of which were submitted by Kenyans in the diaspora. Whereas the earlier directive by the House Business Committee had intended to centrally collect views from all constituencies at identified locations in each county, in keeping with the orders of the High Court sitting in Kerugoya dated 4th October 2024, the collection of views was extended to 5th October 2024 to include all 290 constituency offices and the 47 county women representatives offices, being offices under the Parliamentary Service Commission. This additional time and coverage ensured the inclusion of a higher number of respondents from across the country. Notably, this extended time also saw the submission of additional views through hand delivery to the office of the clerk, as well as through electronic means. Honorable members, on behalf of the House Business Committee and indeed on my own behalf, I wish to appreciate you for your support during the public participation sessions and commend you for your conduct during the exercise. You took a lead in ensuring the public were well informed of the process and refrained from commenting on the merits or otherwise of the motion, whether in public or on the media. This is how it is supposed to be. Contrary to media reports on the general absence of members In the various venues at which public participation was conducted, I wish to clarify that the absence was in keeping with the requirements of the standing orders. Having said that, honorable members, I wish to inform you that the views collected during the exercise have since been collected and compiled into a report which was noted by the House Business Committee at its meeting held yesterday, 7th October 2024. The House Business Committee has designated the Honorable Millie Odhiambo Mabona MP, one of its members, to table the report on its behalf under Order Number 5. At an appropriate time in the course of today's proceedings, I will allow the Honorable Minority Whip a maximum of 15 minutes to give an overview of the process undertaken and the contents of the report. It's expected that as the House debates the motion, members will take into consideration the views of the public as expressed between 2nd and 5th October 2024. I therefore call upon committees to take a keen interest in the report and isolate matters that fall under their respective mandates for possible consideration, reporting, and approval by the House. Honorable members, may I remind the House of the resolution on the limitation of time as resolved on Wednesday, 2nd October 2024. The mover will have a maximum of 60 minutes in moving and a maximum of 30 minutes to reply. All other members will have a maximum of 5 minutes except the leader of the majority party and the leader of the minority party and the member seconding the motion, who will each have a maximum of 10 minutes. This is in addition to the 15 minutes allocated to the minority whip to highlight the contents of the report of the public participation. Honorable members, permit me to also remind members of the provisions of Part 14 of our standing orders on the rules of debate, Part 16, on the rules of debate that ought to guide today's proceedings. Notably, members should strictly restrict their contributions to matters that are relevant to the motion before the House and not the provisions of Standing Order 91, responsibility for statement of fact. The Standing Order notes that a member is solely responsible for the accuracy of any facts which the member alleges to be true and may be required to substantiate any such facts instantly. Additional only members will recall that ordinarily Standing Order 95, closure of debate, and Standing Order 96, adjournment of debate, allow a member to hasten the conclusion of a debate on a motion or delay the conclusion of a debate on a motion, respectively. However, these two standing orders do not apply with respect to the consideration of a special motion, such as the one that is before the House today. I will therefore not entertain any call for the mover to reply or any dilatory motion to be moved until the debate scheduled for today is concluded. Honorable members, I'm sure that you are all aware of the rules of natural justice which require that no person should be condemned unheard. This rule is embodied in our Standing Order 67B2, right to be heard, and pursuant to this standing order, I will accord the Deputy President and or his representatives that opportunity to be heard at 5 p.m. for a maximum of period of 2 hours. Thereafter, the mover will be called upon to reply, following which the House will proceed to vote on the special motion. Further to the communication issued on 1st October, I need to not gainsay the need for the House to conduct itself in the most decorous fashion during today's proceedings. For the best use of the time allotted to members' contribution to the motion, I urge that each member be listened to without interruption. Honorable members, as we commence today's proceedings, permit me to note that I'm aware that yesterday, the Deputy President of the Republic of Kenya held an interview with the local media in which he laid out his defense to the special motion before the House. Whereas Standing Order 85 prohibits members of this House from anticipating debate of a motion for which notice has been given, the Standing Order, when broadly interpreted, also extends to non-members, especially persons affected by such motions. Noting that the special motion is scheduled for debate and voting today, I believe that the Deputy President ought to have exercised restraint and refrained from holding the press interview. It is noteworthy that the Deputy President has been given an opportunity to appear before this House to make his response to the motion in accordance with the rules of natural justice. Be that as it may, I will not wear the hat of a judge on this matter, but permit me to put it on record that the conduct was, to say the least, abhorrent and decided conduct in the light of the proceedings scheduled to commence the House. The House is accordingly guided and will now move to the next business. Members, take your seats. Next order.
Order number 3, messages. Order number 4, petitions. Order number 5, papers.
Majority Leader.
Thank you, Honorable Speaker. I beg to lay the following papers on the table of the House today, Tuesday, 8th October, 2024, morning sitting. 1, special audit report of the Auditor General on illicit financial flows in Kenya. Focus on management of tax exemption on public infrastructure projects by foreign companies for September 2024. 2, annual report and financial statements of Kenya Civil Aviation Authority for the year ended 30th June 2023. 3, the annual report of the National Police Service Commission for the financial year 2023 to 2024. 4, the audited financial statements for the year ended 30th June 2024 from the Central Bank of Kenya. And 5, reports of the Auditor General and financial statements for the year ended 30th June 2024 and the certificates therein in respect of the following. 1, the Retirement Benefits Authority, and 2, the Insurance Regulatory Authority. Thank you, Honorable Speaker.
Thank you, order members. Reduce the levels of conversation. Minority Party Whip, the Honorable Millie Odhiambo.
Honorable Speaker, I beg to lay the following paper on the table of the House today, Tuesday, the 8th of October, 2024. Report of the public participation on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya. Thank you.
Order.
Order number 6, notices of motion. Order number 7, questions and statements. Order number 8, special motion, proposed removal by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya.
Honorable Mwengi Mutuse Ekomas, you may take the floor. Begin. Can the majority and minority leaders approach the chair? Honorable members, as we start the motion, a slight variation on my communication. The majority leader and the minority leaders in the House will prefer to speak immediately after the subject of the motion speaks, before the mover is called upon to reply. I have acceded to their request and it's so ordered.
Thank you, Mr. Speaker, for the opportunity to move the special motion on the impeachment of the Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua. Mr. Speaker and honorable members,
Start Mwenge Mtuse by saying, I beg to move the following motion and read the motion as it is on the order paper. What you probably can skip is reading out all the names of the members which you read. Just say this, the members who signed the motion are set out on the order paper.
Thank you, Mr. Speaker. I beg to move the following motion, that pursuant to the provisions of Article 145 and Article 151B and 2 of the Constitution and Standing Orders number 64 and 65, the House resolves to remove from office by impeachment His Excellency Honorable Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya, on the following grounds. 1, gross violation of Articles 10(2)(a), B and C, Article 27(4), Article 73(1)(a), and Article 2B, Article 75(1)(c), Article 29(2) of the Constitution, and Article 147(1) as read together with Article 131(2)(c) and D of the Constitution. That His Excellency, the Deputy President, has persistently made utterances threatening to discriminate, exclude, and unlawfully deny sections of the people of Kenya and regions of the Republic of Kenya equal opportunities for public service appointments and allocation of public resources. Ground number 2, gross violation of Articles 147(1) and 152(1) of the Constitution by undermining the President and the Cabinet and the effective discharge of national government's executive mandate. That His Excellency, the Deputy President, has made unilateral statements inconsistent with policy positions collectively adopted by the government and contradicted the President on critical matters of governance and the exercise of the President's function as a symbol of national unity. 3, gross violation of Articles 6(2), 10(2)(a), 174, 186(1), 189(1), and the 4th schedule to the Constitution by undermining devolution. That His Excellency, the Deputy President, interfered with the running of Nairobi City County Government by inciting citizens against lawful directives of the county government on the planning and relocation of markets, and publicly disparaging the leadership of the county government and its decisions. 4, gross violation of Article 161 of the Constitution on the institutional and decisional independence of judges. That His Excellency, the Deputy President, has undermined the institutional and decisional independence of a judge through public attacks on a judge of the High Court of Kenya and falsely threatening to file a petition for the removal of the said judge in a matter in which he was a party. 5, gross violation of Article 3(1) and Article 148(5)(a) of the Constitution on the fidelity to the oath of office and allegiance. That His Excellency, the Deputy President, breached his oath of office and allegiance on account of the utterances and actions attributed to the Deputy President under grounds 1, 2, and 3. 6. Serious reasons to believe that His Excellency the Deputy President has committed crimes under sections 13(1)(a) and 62 of the National Cohesion and Integration Act. That His Excellency the Deputy President has persistently made inflammatory, reckless, insightful, public utterances over the last 2 years in contravention of the law. 7. Serious reasons to believe that His Excellency the Deputy President has committed gross economic crimes under sections 45(1), 46, 47(a)(3), and 48(1) of the Anti-Corruption and Economic Crimes Act and sections 2, 3, 4, and 7 of the Proceeds of Crime and Money Laundering Act. That His Excellency the Deputy President has committed gross economic crimes, namely conflict of interest, abuse of office, and conspiracy to commit crimes under the sections highlighted by inexplicably amassing property estimated at Kenya shillings 5.2 billion that is incompatible with his non-legitimate income, and by trading with the office of the Deputy President through proxies. 8. Serious reasons to believe that His Excellency the Deputy President has committed crimes by continuously misleading members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. 9. Gross misconduct that is incompatible with the high calling and dignified status of the office of the Deputy President, a member of the Cabinet, and a member of the National Security Council. His Excellency the Deputy President has publicly attacked and undermined the work of the National Intelligence Service and its officers. Number 10, gross misconduct by openly or publicly insubordinating the President, who is the head of state and government. And number 11, the last ground, gross misconduct by persistently bullying state officers and public officers. Mr. Speaker, the motion is supported by a total of 291 members and is contained in the order paper. Mr. Speaker, in prosecuting this motion, it will be remembered that we gave the notice of motion on Tuesday 1st, 2024, and the House also takes public notice that law and procedurally, the Deputy President did address the nation yesterday, and therefore, part of what he said may form part of what I will be talking about. For purposes of members following what I will be presenting, I choose to be very methodical. I will read the ground. I will restate the provisions of the law that have been violated. I will then briefly state the facts constituting the particulars, and I will tie it up finally with the evidence supporting our allegations. This will make it easy for members to understand what it is that we are accusing the Deputy President of doing. In doing this, Mr. Speaker, I choose to be a prosecutor, and I remove my political cap. I will therefore avoid the bravado and machismo that was displayed yesterday on television, and we will just talk about the law, the facts, and the evidence.
Order, members.
Mr. Speaker,
take your seats, McClap.
Mr. Speaker, honorable members, and Kenyans at large, if I do not talk about my departed relatives, it is because I do not think it is proper to use departed relatives to whip public emotions, It is because I do not think it is proper to use departed relatives to seek public sympathy. And therefore, much as I have also departed relatives, I will not talk about them. Mr. Speaker, before I begin going count by count, allow me also to state on two important questions, and I want honorable members to listen. Two things are important. That this is an historical moment and it is also a constitutional moment because Kenya, under the 2010 Constitution, has never dealt with the impeachment of a deputy president. However, we have dealt in numerous times with the impeachment of governors. And our courts of law have set the threshold on which impeachments should be considered. And I thought from the onset, it is important for me to set out the threshold on which impeachment should be considered, so that as I take you through the evidence that we have, you can gauge the evidence against what the courts of law have decided. Mr. Speaker, allow me to read paragraph 31 of Civil Appeal number 21 of 2014, famously called the Wambora decision. The Wambora decision is now the locus for most of the impeachment cases and has been cited with approval by our Supreme Court. In paragraph 31, the court stated as follows: our reading and interpretation of Article 181 of the Constitution, as read with Section 33 of the County Government Acts, shows that the removal of a governor is the constitutional and political process, underlying constitutional and political process. It is a sui generis process that is quasi-judicial in nature, and rules of natural justice and fair administrative action must be observed. What I'm going to read is the most important part. The impeachment architecture in Article 181 of the Constitution reveals that the removal of a governor is not about criminality or culpability, but is about accountability, is about political governance, as well as policy and political responsibility. Mr. Speaker, the coaching of Article 181 in the Constitution, which relates to removal of a governor, is similar to the coaching of Article 150, which relates to the removal of a deputy governor. And therefore, mutatis mutandis, what the Court of Appeal did state, that the removal of a governor is not about criminal or culpability. It is about accountability, political governance, as well as policy and political responsibility applies to the removal of a deputy president. Mr. Speaker, the standard, I am prepared this morning to discharge my burden of proof, because he who alleges must also prove. And I am ready to discharge it to the required threshold. Therefore, Mr. Speaker, in consideration of the time that I have been given, allow me now to go to the specific grounds. Ground number one, Mr. Speaker, ground number one, briefly. On ground number one, Mr. Speaker, we have alleged that the Deputy President has grossly violated the Constitution, and particularly Article 10(2)(a), Article 10(2)(b) and C, Article 27, Article 73, Article 75, Article 129, Article 147, and Article 131. Mr. Speaker, for clarity, allow me to read out the specific provisions so that members may relate with what we are saying. Article 10 is about national values and principles of governance. Article 10(2)(b) states as follows: the national values and principles of governance include patriotism, national unity, important national unity, sharing and devolution of power, the rule of law, democracy, and participation of the people. B, human dignity, equality, social justice, inclusiveness. Underline the words national unity and inclusiveness. C, good governance, integrity, transparency, and accountability. Mr. Speaker, we have also alleged that the Deputy President has breached Article 27 of the Constitution. Article 27 of the Constitution is about equality and freedom from discrimination. In particular, the Article 27(4) states as follows: the state shall not discriminate directly or indirectly against any person on any ground, including race, sex, pregnancy, marital status, and so forth and so forth. Important, the state shall not discriminate. Mr. Speaker, we have also alleged that the Deputy President has breached Article 73(1) of the Constitution. In particular, Article 73(1) is on leadership and integrity, and it speaks to the authority that is assigned to a state officer. And it states as follows: Article 73(1)(a), that the authority assigned to a state officer is a public trust to be exercised in a manner that is consistent with the purposes and objects of this Constitution. Article 73(2)(b) states that the guiding principles of leadership and integrity include objectivity and impartiality in decision-making and in ensuring that decisions are not influenced by nepotism, favorism, underline favorism, other improper motives or corrupt practices. Mr. Speaker, we can go on and on to demonstrate in Article 75, under Article 75(1)(c), that the conduct of a state officer shall behave, whether in public and official life, in private life, or in association with other persons, in a manner that avoids C, demeaning the office that the officer holds. Mr. Speaker, I am taking time on this one because it is important to demonstrate that the Deputy President has not lived up to the high calling of the office that he holds, and thus has violated the Constitution. Article 129 is about the principles of executive authority. And particularly, we have said that the Deputy President has breached Article 129(2). Article 129(2) states that the executive authority shall be exercised in a manner that is compatible with the principles of service to the people of Kenya and for their well-being and benefit. We have also alleged that the Deputy President has breached Article 147 in conclusion on this particular ground. And Article 147 is about the functions of the Deputy President. And it provides that the Deputy President shall be the principal assistant to the President and shall deputize for the President in the executions of the President's functions. Article 131 is the one that provides for the authority of the President. And under 131(2), it provides as follows: that the President shall A, respect, uphold, and safeguard the Constitution, and C, promote and enhance the unity of the nation. Promote and enhance the unity of the nation. Mr. Speaker, It is our allegation that on numerous occasions in the last 2 years, the Deputy President has used divisive language. He has described the Kenya government as a company. He has described the Kenya government as a shareholding company, where it is only the shareholders of the company who should benefit. And it is our contestation that that particular shareholding language contradicts and contravenes and violates all the provisions of the Constitution that I have highlighted above. Mr. Speaker, the Constitution does require, even at the preamble, recognizes that Kenya is a multi-ethnic society. We have about 44, I think 45 ethnic groups in this country, big and small. And all of them are recognized by our Constitution, and all of them need to enjoy their equal rights. And the Deputy President has consistently told Kenyans in several places of this country that some will benefit from government and others will not benefit from government. Mr. Speaker, I need not waste a lot of time prosecuting this point, because those of you who listened to the Deputy President yesterday, he did admit that he has been using the shareholder and company language against Kenyans. The only thing that he did, and when there is an admission by the accused person, the prosecution does not need to prove a point. And therefore, I will be urging members of this House to find that this allegation is proved, and to find that the Deputy President indeed did admit that he has been using the shareholder language, only that for the first time, and this is important, Mr. Speaker, for the first time, the Deputy President did, while admitting, he said that he has been referring to the shareholder company language in reference to coalition agreements. The evidence that I'm going to present shortly will demonstrate that he has never, in his utterances in the last 2 years, talked about coalition agreements or power sharing deals that were signed before the election among the Kenya Kwanza political formation. He has been talking directly to communities. He went to Kajiado. He told the people of Kajiado that they do not have shares. He went to Kitui during a church service at AIC Kitui, and he told the people of Ukambani that they should not even be having a cabinet minister in government. He went to Bungoma and told the people of Bungoma that they have had too many appointments in government and the votes they brought are not equivalent to the votes they brought. He went to Nandi and told the people of Nandi that they are a major shareholder and they will benefit more than others in this government. And he has been using the language in direct reference to communities, not to political party formations. Mr. Speaker, without belaboring this point, allow me now to request that the evidence on ethnic profiling and divisive shareholder politics as contained in video 1 and video 4 be played for the House to take note of the evidence.
Hii serikali ni kampuni na ni ya shares. Si ndio? Ni ya shares. Kuna wenye kampuni, wale wako
Order, members.
Kuna wale wako na chache, kuna wale hawana.
The technicians who are playing, I kindly request that you repeat and you play it with on a higher volume. Please pause it. And I also request, Mr. Speaker, you direct that during the time that we are playing our clips, our time be paused. Please repeat so that members may appreciate and also Kenyans may know that we are not persecuting. We are not persecuting.
Serikali ni kampuni na ni ya shares. Si ndio? Ni ya shares. Kuna wenye kampuni, wale wako na shares mingi, kuna wale wako na chache, kuna wale hawana. Sasa nyinyi mliinvest kwa hii kampuni ya William Ruto na Rigathi Gachagua. Sasa lazima mvune. Yule ambaye alipanda atafanya nini? Simulipanda? Simuliamuka mapema? Mukasema mutaki kusikia mambo ya ile system na nini? mukainvest, mukapanda, mukapalilia, mukaweka mbolea, mukamwagilia maji, wakati ya kuvuna ndio huu. Na itakuwa namna hiyo. Najua wengine wananikashifu ati mimi nasema ati wale walipanda wavune kwanza. Iko makosa? Iko makosa? Hata hao watavuna lakini wangoje. Si wale walipanda na wavune kwanza. Wakishavuna wavune ile tabaki kidogo, wale wakupanda waingie watafute huko nini ile itapatikana wachukue wakwende. Si iko namna hiyo? Na itakuwa namna hiyo. Ndio watu wakipiga kura waelewe hii kura tukusema nini. Hii kura iko na maana. Nyinyi hamwezi piga kelele huko, mpige kelele. Mnasema William Ruto ni bure, hawezi, mnaita yeye majina, alafu akipata, akigawa, mnapiga laini atibuko pale mbele. Ati mnataka mpite wale walisema anafaa atibukue pale mbele. Inawezekana? Mimi kazi yangu pale kwa Ikulu ni hiyo. Ni kupanga hiyo laini. Hapo ni kazi mimi napanga hapo. Mimi naangalia kwa laini, nikiona wewe ulipanda, natoa wewe nyuma, napeleka wewe mbele.
Mr. Speaker, in the interest of time, I have 14 other videos that the Deputy President is recorded speaking in different parts of the country. Same language, saying that Kenya is a company, and a company belongs to shareholders. It is clear from the clip. I am not the one who made that clip. The person talking in the clip is none other than the Deputy President of the Republic of Kenya. Mr. Speaker, the office of the Deputy President is a national office. The territory of the Republic of Kenya is defined in the Constitution. The territory of the Republic of Kenya is known. The ethnic communities of the Republic of Kenya are all supposed to enjoy benefits from the government. And therefore, I am inviting members of this assembly to find that the Deputy President has breached all the articles of the Constitution as contained in this ground. Mr. Speaker, it needs no gainsaying that divisive ethnic politics are dangerous. You need not look further than the country of Yugoslavia. What ethnic politics did to the country of Yugoslavia. You need not look further than the country of Bosnia. What ethnic politics did to the country of Bosnia. You need not look further than the country of Rwanda. What ethnic politics did to Rwanda. You need not look further than the country of Burundi. What ethnic politics did to the country of Burundi. Until today, they are trying to reconfigure their state. You need not look further than Sudan. What ethnic politics have done to the good Republic of Sudan that was once a stable state. You need not look even further than the country of Nigeria. Mr. Speaker, Ethiopia. Mr. Speaker, our own country, Kenya, 2007, we experienced post-election violence. You would remember that in 1992, there were clashes in Molo. And Mr. Speaker, character is important in evidence. The Deputy President, there is evidence to show that during the post-election clashes in Molo, he was a district officer in Molo. Character is very important in deciding evidence and in persuasion. Mr. Speaker, in 1992, there were clashes in Likoni, and our tourism has never recovered. Mr. Speaker, we need not go that direction again. And a person occupying the high office of the Deputy President, if they want to take Kenya in that direction, the time has come for the National Assembly to stand on its feet to defend the Constitution and to impeach the Deputy President. So that even if not on any other ground, for purposes of dividing Kenya, the Deputy President today must be impeached. Mr. Speaker, allow me to turn to my ground too. Mr. Speaker, on ground two, I am alleging that the Deputy President has violated Article 147(1) of the Constitution and has also violated Article 152(1) of the Constitution. Because all of us are not lawyers, please allow me, for purposes of clarity, to read those two articles for members to appreciate. Article 147 of the Constitution does state as follows. Functions of the Deputy President. The Deputy President shall be the principal assistant to the President and shall deputize for the President in the execution of the President's functions. Article 152.1 states as follows. Composition, the Cabinet consists of the following. 1, the President. 2, the Deputy President. The person I am pleading to the House today to impeach is a member of Cabinet. C, the Attorney General. And D, not fewer than 14 and not more than 21 Cabinet secretaries. Mr. Speaker, the importance of this is to show that the Deputy President is assigned to assist the President and is a member of the Cabinet. And what we are demonstrating, Mr. Speaker, because of time, is that the Cabinet has been making decisions. The Deputy President sitting in Cabinet, Cabinet memos come before Cabinet, they are discussed in Cabinet, and then the Deputy President moves out of Cabinet to contradict those decisions. In proving this, I am relying on the affidavit of Mercy Wanjau. Mercy Wanjau is the Secretary to the Cabinet. And in our affidavit that is in my bundle of documents, at page 77 to 79, Mercy Wanjau does, in oath, state that the Cabinet made a decision to rejuvenate Nairobi River. And when that decision was made, because the law requires that settlement be 30 meters away from a river, the Deputy President was sitting in Cabinet. The Deputy President is actually the chair of Cabinet subcommittees, and I believe he chaired the Cabinet subcommittee that made this decision. However, for political expedience, immediately after the decision was made, the Deputy President moved out of Cabinet and went to the public to oppose the decision. Mr. Speaker, that is inconsistent with the principle of collective responsibility. That is inconsistent with the requirement that once a decision is made, you need to live by that decision. During his televised interview yesterday, the Deputy President said that he's the most compassionate person. He cares so much about the poor. This afternoon, honorable members of Parliament, I want to ask the following question, and if I may be heard in silence. The Deputy President of the Republic of Kenya is on record as being the person who ordered demolitions in Mavoko constituency in Athi River. Yes. Yesterday, he gave half-truths to Kenyans, saying he opposed this Cabinet decision because it was unconstitutional, because he's very compassionate about Kenyans. Why didn't he also go ahead to say that he's also the one who led demolitions in Mavoko constituency? Are the people of Mavoko constituency lesser citizens of this republic? Or is it because in his own thinking, they are not shareholders of this republic? And therefore, I'll be pleading with honorable members